judgment in the appeal, Ivey and Genting casinos.
Lord Hughes will give the judgment to the court.
Punto Banco Baccarat is a casino gambling game which is designed to be a game of pure chance. Cards are delivered face down from the shoe, two to each of two positions. They're called banker and player, but they might just as well be called red and black, since nobody but the croupier touches any of the cards. The gambler bets on which of the two positions will turn out to have the better cards, which means, in this game, nearest to a total count of 9. His bet is placed before any of the 4 cards is extracted from the shoe. After all 4 have been dealt, the croupier turns the cards face up and reveals which of the 2 positions has the better total. The game is of pure chance because the shoe has 6 or 7 packs of cards and you can't predict the order in which they emerge. Mr. Ivey is a professional gambler. He won approximately £7 million over an evening and the following morning from Crockfords Casino in London. When Crockfords reconstructed what he had done from the closed-circuit television recording, it became clear that he had developed a highly sophisticated system. The cards used all had the same pattern on the back, but it was printed to a very tiny extent asymmetrically, so that the pattern was, by a millimetre or less, fractionally nearer to one side of the card than the other. Mr. Ivey exploited that tiny difference, and the system that he used has been given the label, it seems, in the gambling world, edge sorting. It works like this. Since all the cards have the same tiny asymmetry on the back, even if you can spot it, it tells you nothing about the value of the card. But what Mr. Ivey did was to play right through a complete shoe of 6 packs. And each time the croupier turned the cards face up, he persuaded her to turn the better value cards end to end and the rest side to side. He did this by affecting to be superstitious. He was a big spending customer, and the croupier humoured him without having any idea of the significance of what she was being asked to do. The result, however, was that when the same cards were used again in a second shoe, Mr. Ivey could tell from the leading edge of the first card, as it lay in the shoe before being extracted, whether it was a high value or a low value card. And that was enough to give him the advantage he needed. Whereas on the first shoe he won some and lost some in the ordinary way and had no advantage, on the second shoe he had a high proportion of wins, hence finishing some £7 million up. The moment the cards were to be changed, he abandoned the game. Crockfords had never met this practice before. When they worked out what he had done, they refused to pay, so he sued for the £7 million. Whether he was entitled to it or not depended on the end on whether what he did was cheating. It was no doubt true that Crockfords might have been better prepared than they were if they'd known about the practice, but if they were cheated, they weren't liable to pay. It's very often true that the victim of a confidence trick could have spotted it if he'd thought about it, but it's still a trick. The judge and the Court of Appeal both held that what had happened was cheating, and so Mr. Ivey couldn't claim the money. They gave somewhat different reasons. This court agrees that it was cheating. The key point is that Mr. Ivey did not just watch the cards with a trained eye, but rather took active steps to fix the shoe. If he'd got surreptitious access to the shoe and rotated the cards so that the high-value ones were one way round and the rest the other, that would clearly be cheating. He achieved the same result by duping the croupier, and that is cheating as well. So his appeal fails. These rather unusual facts give rise to a number of questions of law. Mr. Ivey's argument depended on the judge having found, which he did, that Mr. Ivey was truthful when he gave evidence that he didn't think what he had done was cheating. He considered it to be what he called legitimate advantage play. In other words, he said he was simply being clever and exploiting knowledge which he had and the casino didn't have. Cheating, Mr. Ivey argued, necessarily involves doing something which is dishonest. And he argued he was not dishonest because he genuinely thought that what he was doing was legitimate. The legal questions are answered in the court's unanimous judgment. In a fairly brief summary, the answers are these. One, it's probably not true that all cheating involves dishonesty. The runner who trips up his opponent is undoubtedly cheating, but it's not at all clear that everybody would call it dishonest. Two, cheating as a concept in gambling has existed for some hundreds of years. The expression dishonesty, on the other hand, wasn't particularly current in the law until the Theft Act 1968. And there's no reason to complicate the concept of cheating by adding an extra requirement of dishonesty. If all cheating is dishonest, as some may well say, the extra requirement would add nothing. If some cheating is not normally described as dishonest, perhaps like the runner tripping his opponent, then the extra requirement would wrongly take something away from cheating. Three, in this case, what Mr. Ivey did probably would ordinarily be described as dishonest because he duped the croupier into unwittingly fixing the shoe. And fourth, in any event, the notion that a person is only dishonest if he himself knows that other people would think that he was is wrongly based in law. That idea derives from a decision of the Court of Criminal Appeal in 1982 called the Queen against Gosh. But whereas it has remained the test of dishonesty in criminal cases, that conflicts with the test for dishonesty when it comes up in civil cases, as it very often does. The court holds that the test ought to be the same, whichever sort of court the question comes up in. And on examination, moreover, the reasoning in Gosh is faulty and ought to give way to the clearer test which is applied in civil cases. The test for dishonesty involves first deciding what the individual knew about what he was doing and about what the surrounding circumstances were, and then, assuming that state of knowledge, deciding whether the ordinary decent member of society would say that what was done was dishonest. If that is what the ordinary person would say, the behavior does not become honest because the individual in question has different or lower standards. So Mr. Ivey's genuine belief that he was entitled to do what he did doesn't prevent it from being dishonest. Quite a lot of confidence tricks, which any ordinary person would call dishonest, involve exploiting knowledge which the perpetrator has and the target hasn't.